It's the content creator with force like Darth Vader. One path is the way that I'm taking, getting closer to God in a tight situation. We back again, and we still inside the book, Cracking the Code, third edition, reading a memorandum of law on the name. Enjoy, people. Many people are involved in diligent research concerning the use of all capital letters for proper names. Example given, John Paul Jones as a substitute for John Paul Jones in all court documents, driver's licenses, bank accounts, birth certificates, etc. Is the use of all capital letters to designate a name some special English grammar rule or style? Is it a contemporary American style of English? Is the use of this form of capitalization recognized by educational authorities? Is this an official judicial or U.S. government rule and or style of grammar? Why do attorneys, court clerks, prosecutors, judges, banks, credit card companies, utility companies, etc. always use all capital letters when writing a proper name? What English grammar experts say. One of the foremost authorities on American English grammar style composition and rules is the Chicago Manual of Style. The latest 14th edition, published by the University of Chicago Press, is internationally known and respected as a major contribution to maintaining and improving the standards of written or printed text. So we can find no reference in their manual concerning the use of all capitalized letters for the proper name or any other usage. We wrote to the editors and asked this question: is it acceptable, or is there any rule of English grammar to allow a proper name to be written in all capital letters? For example, if my name is John Paul Jones, can it be written as John Paul Jones? Is there any rule covering this? The editorial staff of the University of Chicago answered, writing names in all caps is not conventional. It is not Chicago style to put anything in all caps. For instance, even if Gone with the Wind appears on the title page all in caps, we would probably render it Gone with the Wind in a bibliography. The only reason we can think of to do so is if you are quoting some material where it is important to the narrative to preserve the casing of the letters. We're not sure in what context you would like your proper name to appear in all caps, but it's likely to be seen as a bit odd. Law is precise. Every letter, capitalization, punctuation mark, etc. in a legal document is utilized for a specific reason and has legal, in other words, deadly force consequences. If, for instance, one attempts to file articles of incorporation in the office of a Secretary of State, if the exact title of the corporation, down to every jot and tittle, is not exactly the same each and every time the corporation is referenced in the documents to be filed, the Secretary of State will refuse the filing. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person. It is therefore an eminently valid and possibly crucial question as to why governmental courts, and agencies purported to exist in some undefined, unproved manner within the jurisdiction of this state always insist on capitalizing every letter in a proper name. Mary Newton Bruder, PhD, also known as the Grammar Lady, who established the Grammar Hotline in the late 1980s for the Coalition of Adult Literacy, was asked the following question: why do federal and state government agencies and departments, judicial and administrative courts, insurance companies, etc., spell a person's proper name in all capital letters? For example, if my name is John Paul Jones, is it proper at any time to write my name as John Paul Jones? Dr. Bruder's reply was short and to the point. There must be some kind of internal style. There is no grammar rule about it. It seemed that these particular grammatical experts had no idea why proper names were written in all caps. So we began to assemble an extensive collection of reference books authorized by various publishers, governments, and legal authorities to find the answer. What English grammar reference books say? Manual on Usage and Style. One of the reference books we obtained was the Manual on Usage and Style, the 8th edition, published by Texas Law Review in 1995. Section D, capitalization, paragraph D1(1) states, always capitalize proper nouns. Proper nouns, independent of the context in which they are used, refer to specific persons, places, or things. Example given, Dan Austin, Rolls Royce. Paragraph D3(2) of Section D states, capitalize people, state, and any other terms used to refer to the government as the litigant. Example given, the people's case, the state's argument, but do not capitalize other words used to refer to litigants. Example given, the plaintiff, defendant Manson. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reasons. In either ignorance of the law is no excuse, or violation, one violating the law he enforces on others is acting under title of nobility and abrogating the principle of equality under the law. Of laws, they continue to write plaintiff, defendant, the state of Texas, and proper names of parties in all capital letters on every court document. The Elements of Style. Another well-recognized reference book is The Elements of Style, 4th edition, written by William Struck Jr. and E.B. White, published by Allen and Bacon in 1999. Within this renowned English grammar and style reference book is found only one reference to capitalization, located within the glossary at proper noun, page 94, where it states, the name of a particular person, Frank Sinatra, place, Boston, or thing, Moby Dick, proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book on English Usage. The American Heritage Book on English Usage, a practical and authoritative guide to contemporary English, published in 1996 at Chapter 9, Email Conventions and Quirks, Informality, states, to give a message special emphasis, an emailer may write entirely in capital letters. The device email is referred to as screaming. Some of these visual conventions have emerged as a way of getting around the constraints on data transmission that now limit many networks. Here's a reference source for contemporary modern English that states it is of an informal manner to write every word of specifically an electronic message, aka email, in capital letters. They say it is screaming to do so. By standard definition, we presume that it is the same as shouting or yelling. Are all judges, as well as their court clerks and attorneys, shouting at us when they corrupt our proper names in this manner? If so, what happened to the decorum of a court if everyone is yelling? Is the insurance company screaming at us for paying the increased premium on our policy? This is doubtful as to any standard generalization, even though specific individual instances may indicate this to be true. It is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this imply that those in the legal profession are writing our Christian names informally on court documents? Are not attorneys in the courts supposed to be specific, formally writing all legal documents to the letter of the law? If the law is at once both precise and not precise, what is its significance, credibility, and force and effects? New Oxford Dictionary of English. Oxford University Press publishes the New Oxford Dictionary of English, considered the foremost authority on the British English language. This dictionary is also designed to reflect the way language is used today, through example sentences and phrases. We submit the following definitions from the 1998 edition. Proper noun, also proper name. Noun, a name used for an individual person, place, or organization, spelled with an initial letter capitalized. Example given, Jane, London, Oxfam. Name, noun. In the first sense, a word or set of words by which a person, animal, place, or thing is known, addressed, or referenced to. My name is Parsons, John Parsons. Kalwechser is the German name for lime water. Verb. In the third sense, identify by name. Give the correct name for the dead man has been named as John McIntosh. Phrases. In the second sense, in the name of, bearing, or using the name of a specified person or organization. A driver's license in the name of William Sanders. Newberry House Dictionary of American English. From the Newberry House Dictionary of American English, published by Monroe Allen Publishers, Incorporated, 1999. Name, a noun, a word by which a person, place, or thing is known. Her name is Diane Daniel. We can find absolutely no example in any recognized reference book that specifies or allows the use of all capital names, proper or common. There is no doubt that a proper name needs to be grammatically correct, must be written with only the first letter capitalized, with the remainder of the word and the name spelled with lowercase letters. U.S. Government Style Manual is the spelling and usage of a proper name defined officially by U.S. government. Yes, the United States Government Printing Office in their Style Manual, March 1984 edition, the most recent edition published as of March 2000, provides comprehensive grammar, style, and usage for all governmental publications, including court and legal writing. Chapter 3, Capitalization, at subsection 3.2, prescribes rules for proper names. Proper names are capitalized. Examples given are Rome, Brussels, John Macadam, Macadam family, Italy, Anglo-Saxon. At Chapter 17, Court Work, the rules of capitalization as mentioned in Chapter 3 are further reiterated. 17.1, Court work differs in style from other work only as set forth in this section. Otherwise, the style prescribed in the preceding sections will be followed. After reading subsection 17 in entirety, we found no other references that would change the grammatical rules and styles specified in Chapter 3 pertaining to capitalization. At subsection 17.9, the same official U.S. governmental manual states, in the title of states, the first capital, in the title of cases, the first letter of all principal words are capitalized, but not such terms as defendant and appellee. This wholly agrees with Texas Law Review's manual on usage and style as referenced above. Examples shown in subsection 17.12 are also consistent with the aforementioned subsection 17.9 specification, that is, all proper names are to be spelled with capital first letters, the balance of each spelled with lowercase letters. Grammar, punctuation, and capitalization. The National Aeronautics and Space Administration, or NASA, has published one of the most concise U.S. governmental resources on capitalization. NASA publication SP 7084, Grammar, Punctuation, and Capitalization, a handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia. At Chapter 4, Capitalization, they state in 4.1 Introduction, first, we should define terms used when discussing capitalization. All caps means that every letter in an expression is capital, like this. Caps and LC means that the principal words of an expression are capitalized, like this. Caps and small caps refer to a particular font of type containing small capital letters instead of lowercase letters. Elements in a document, such as headings, titles, and captions, may be capitalized in either sentence style or headline style. Sentence style for capitalization of the first letter and proper nouns, of course. Headline style called for capitalization of all principal words, also called caps and LC. Modern publishers tend toward a down style of capitalization, that is, toward use of fewer capitals rather than an up style. Here we see that in headlines, titles, captions, and in sentences, there is no authorized usage. There is no authorized usage of all caps. At 4.4.1, capitalization with acronyms, we find the first authoritative use for all caps. Acronyms are always formed with capital letters. Acronyms are often coined for a particular program or study and therefore require a definition. The letters of the acronym are not capitalized in the definition unless the acronym stands for a proper name. Wrong. The best electronic publishing systems combine what you see is what you get. WSIWYG features. Correct. The best electronic publishing systems combine what you see is what you get. WYSIWYG features. But Langley is involved with the National Aeroplane Program. This cites by example that using all caps is allowable in an acronym. Acronyms are words formed from the initial letters of successive parts of a term. They never contain periods and are often not standard, so that definition is required. Could this apply to lawful, proper Christian names? If that were true, then John Smith would have to follow a definition of some sort, which it does not. For example, only if John Smith were defined as John Orley, Holistic Nutrition of Smith Medical Institute to Holistics, John Smith would this apply. The most significant section appears at 4.5, administrative names. Official designations of political divisions and of other organized bodies are capitalized. Names of political divisions: Canada, New York State, United States, Northwest Territories, Virgin Islands, Ontario Province, names of governmental units, U.S. Government, Executive Department, U.S. Congress, U.S. Army, U.S. Navy. According to the official U.S. government publications, the states are never to be spelled in all caps, such as New York State. The proper English grammar and legal style is New York State. This agrees once again with Texas Law Review's Manual on Usage and Style. Legal fiction doctrine allows the courts to assume anything. The Real Life Dictionary of Law. The authors of the Real Life Dictionary of Law, Gerald and Kathleen Hill, are accomplished scholars and writers. Gerald Hill is an experienced attorney, judge, and law instructor. Here is how the term legal fiction is described. Legal fiction, noun, a presumption of fact assumed by a court for convenience, consistency, or to achieve justice. There is an old adage: fictions arise from the law, and not law from fictions. Oran's Dictionary of Law. From Oran's Dictionary of Law, published by the West Group, 1999, within the definition of fiction is found that of legal fiction. A legal fiction is an assumption that something that is or may be false or non-existent is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing a lawsuit to throw a non-existent John Doe off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Merriam-Webster Dictionary of Law. Merriam-Webster Dictionary of Law, 1996 states, legal fiction, something assumed in law to be fact, irrespective of the truth or accuracy of that assumption. Example, the legal fiction that a day has no fractions. Fields versus Fairbanks, North Star Borough, case from 1991. This is the reason behind the use of all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real, flesh and blood man or woman. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not adhering to their own recognized authorities. In the same respect, by identifying their own government entity in all caps, they are legally presuming it to be so. As stated by Dr. Mary Newton Bruder in the beginning of this report, the use of all caps for writing a proper name is an internal style for what is apparently a predetermined usage and at this point, unknown jurisdiction. The main key to a legal fiction is assumption, as noted in each definition above. Conclusion: there are no official or unofficial English grammar style manuals or reference publications that recognize the use of all caps when writing a proper name. To do so is by juristic license of arbitrary presumption or assumption, irrespective of the facts pertaining. Arbitrary right of assumption is a self-serving fiction of the law. An important issue concerning this entire matter is whether or not a proper name written in all caps can be substituted for a lawful Christian name or any proper name, such as State of Florida. For State of Florida is the assertion of all capital letters names legal. For State of Florida, is the assertion of all capital letters names legal? If so, from where does this practice originate and what enforces it? Legal fiction may be employed when the name of a person is not known by using the fictitious name John Doe. This is understood by all and needs little explanation. If there is no way to identify someone, John Doe or Jane Doe is presumed or assumed to identify the unknown party until the proper name can be discovered. In all cases, a legal fiction is an assumption of purported fact without having shown the fact to be true or valid. Legal fictions can be applied to many different situations. Conversions of a true name to an all caps version is one of them. It is an acceptance with no proof. Simply to assume is to pretend. Oren's Dictionary of the Law says that the word assume means 1. To take up or take responsibility for, to receive, to undertake, see assumption. Number 2, to pretend. Number 3, to accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meanings of the second and third definitions with that of the first. Pretending and accepting without proof are of the same understanding and meaning. However, to take responsibility for and receive, in other words, assumption, does not carry the same meaning. Owens defines assumption as formally transforming someone else's debt into your own debt. Compare guarantee. The assumptions of a mortgage usually involves taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings for the word assume are combined? In a literal and in definitive sense, the meaning of assume would be the pretending acceptance without proof that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining all caps usage, such artifice is an assumption or pretension that the juristic person, legal entity named has received and is responsible for a debt of some sort. Use of the name John P. Jones in place of the proper name John Paul Jones implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unproven assumption is made, unless the assumption is proven wrong, it is considered valid. Please go no further until you understand and comprehend exactly what the above paragraphs have stated. If necessary, reread the above until you have a full understanding of what is involved in the meaning of a name spelled in all capital letters. An assumed debt is valid unless proven otherwise. An unrebutted affidavit, claim, or charge stands as truth in commerce. See Maxim of Commerce in glossary. This is in accord with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps, resembling a proper name, but grammatically not a proper name, is being held as a debtor for an assumed debt. Did you incur that debt? If so, how and when? Where is the contract of indebtedness you signed and the proof of default thereon? What happens if the proper name, example given, John Paul Jones, answer for or assumes the fabricated name, example given, John P. Jones? The two become one and the same. This is the crux for the use of the all caps name by the U.S. government and the states. It is the way that they can bring someone to the de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purpose of some manner of assumed debt. Why won't they use the state of Texas or John Doe in their courts or on driver's license? What stops them from doing this? Obviously, there's a reason for using all caps names, since they are very capable of writing proper names, just as their own official style manual states. The reason behind this practice is found within the definitions as cited above. At this point, this should be very clear to every reader. The legalities of all capital letters names. We could go on for hundreds of pages citing the legal basis behind the creation and use of all capital letters names. In a nutshell, fabricated legal persons, such as the state of Texas, can be used to fabricate additional legal persons. Bastard legal persons originate from any judicial government actor that wishes to create them, regardless of whether he, she, it is empowered by law to do so or not. However, a law can never originate from a fictional foundation. The generic and original U.S. Constitution was validated by treaty between individual nation states, all of which are artificial corporate entities since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nation states of that treaty. Representatives of the people in each nation state agreed upon and signed it. The federal government is not only created by it, but is also bound to operate within the guidelines of constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the generic U.S. Constitution. What is created according to the lawful process or outside of lawful process. Executive orders and directives. For years, we have researched the lawful basis for creating all caps juristic persons and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all. Executive orders and directives. They are color of law without being valid laws of due process. These executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws. Rather, they are laws based on fictional beginnings and are the inherently defective basis for fictional laws. They are regulated and promulgated by administrative code, rules, and procedures, not due process. Currently, executive orders are enforced through the charade known as Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. Lincoln established executive orders. 85 years after the independence of the United States, 7 southern nation states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost, and Congress was adjourned sine die, or without day. This meant that there was no lawful quorum set to a specific day and time to reconvene, which, according to Robert's Rules of Order, dissolved Congress. This dissolution automatically took place because there was no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the states. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority or lawful due process of the Constitution. Solely in his capacity as Commander-in-Chief of the U.S. military, Lincoln called Congress into session under authority of martial law. Since April of 1861, Congress had not met based on lawful due process. The current Congress is a legal fiction Congress based on nothing more holy than so what? What are you going to do about it? Legal fiction laws, such as the Reconstruction Acts and the Lieber Code, were instituted by Lincoln soon thereafter and became the basis for the current laws in the U.S. thereby. Every purported act in effect today is based on colorable, fictitious entities created arbitrarily and without verification, lawful foundation, or lawful due process, all originating from and existing in military martial law jurisdiction. Military martial law jurisdiction equal jurisdiction of war, equal win-lose interaction consisting of eating or being eaten, living or dying, food chain, equal law of necessity, equal suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy, or avoid being eaten, killed, or destroyed, equal no law, equal lawlessness, equal complete absence of all lawful basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity, equal no law object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence, equal no bona fide enforceable contract, equal no valid enforceable nexus, equal absolute right to engage in any action of any kind in self-defense, equal complete and total right to disregard any alleged jurisdiction and demands from self-admitted laws, committed naked criminal aggression without any credibility, and right to demand allegiance and compliance from anyone. Every president of the United States since Lincoln has functioned by executive orders issued from a military martial law jurisdiction, with the only law being the law of necessity. In other words, the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, try to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win-lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reaffirmation of operational authority under the war powers begins. Now, therefore, I, Harry S. Truman, President of the United States of America, acting under and by virtue of the authority vested in me by Section 5B of the Trading with the Enemy Act of October 6, 1917, 40 Stat 415, as amended, Section 5B of Appendix to Title 50, and Section 4 of the Act of March 9, 1933, 48 Stat 2, Sick Transit Rights, Substance, Truth, Justice, Peace, and Freedom in America, the land of the free and the home of the brave, the abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. The American law in this country, the law in effect in all but a few states until mid-19th century, was the pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law. Roe versus Wade, 410 U.S. 113. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on a fictional legal foundation. In other words, executive orders and directives executed under authority of the war powers. Most states still have a reference to the common laws within their present-day statutes. For example, in the Florida Statutes 1999, Title I, Chapter 2, at subsection 2.01, common law and certain statutes declared in force, it states, the common and statute laws of England, which are of a general and not a local nature, with the exception hereinafter mentioned down to the 4th day of July, 1776, are declared to be of force in this state, provided the said statutes and common law be not inconsistent with the Constitution of the laws of the United States and the act of the legislature of this state. History. November 6, 1829. Note that the basis of the common law is an approved act of the people of Florida by resolution on October 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws as a result of acts of the Florida legislature and the United States now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction law, aka statutes, rules, and codes based on executive order and not the due process specified within the organic constitution, existing and functioning under the law of necessity ab initio. They are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely rules of rulership. In other words, organized piracy, privilege, plunder, and enslavement, invented and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanics to accomplish any results other than disruption, conflict, damage, and devastation. I'm going to pause right here, and we'll come back and read part 2 to this particular excerpt inside of this book, Cracking the Code, the 3rd edition. Oh, people. Please look up the words that you're not familiar with so you can better understand what we're reading. Like, share, and subscribe, people. Like, share, and subscribe, people. And make sure, once again, to look up the words that you're not necessarily familiar with. This will help you better understand. Be peaceful, stay blessed, and pray to pass the Lord's test. I will talk with you guys later. Make sure you like, share, and subscribe, people. Like, share, and subscribe.